Howdy, and welcome back to Kosseff Chapter 1, Video 3 of 4. So, continuing on in your book, after we talk about how FTC has the power to regulate, on page 5, it starts talking about the Windham. Windham is a case you will hear referred to in cybersecurity. You'll hear people talk about Windham, and here's why. Windham was the challenge the FTC and said, guess what, guys? You don't have the authority to use FTC Act Section 5 to regulate data. You don't have the power, guys. So they, instead of working with the FTC, went to the fought it and said, you don't have the power. It's a basic question of overextending your authority. And if you will look, this went to the Third Circuit, which includes Delaware. What do we know about Delaware? Delaware is where we have our only state with specific business law courts. So this is something that even though the other circuits may not be bound to follow, it is very persuasive. They will look to the Third Circuit. So I don't know if Windham expected special treatment, but basically Windham Windham challenged the consent order. Now there's two words, consent agreement and consent order. Consent agreement is where the entity sits down with the FTC and works out a plan. The consent order is where the FTC tells the entity what's going to happen. Typically the FTC wants an entity to sit down and work out a plan, but, Windham's saying, nope, not going to do it. Tell us what we have to do, and then we're going to fight you in court. We're Windham Worldwide Corporation. We're a hotel chain. We're going to file this in the Third Circuit because we're incorporated in Delaware. And it failed, okay? And the things you want to understand is to look on page 6 and then compare that to, and I know I'm walking you through like you're in junior high, but for some technical people, when they look at this book and say, what? No algorithms, no graphs, right? That I want you to look at the list on page 6, storing credit card data in clear text, allowing simple passwords, failure to use firewalls, failure to adequately oversee the cybersecurity that linked to the central servers. Think about Target. Their breach came through an HVAC contractor, a third-party vendor. Allowing vendors to have unnecessary access to Windham, and failure to take reasonable measures for security investigations. So as you read this, and I'm not reading it all to you, you still need to be responsible for reading this. And you look at 6, you begin to see commonality. This is what I mean when we have commonality. Developing an information security program, identifying risk, preventing LabMD employees from unnecessary accessing personal information, training employees, requiring common authentication, maintaining and updating operating systems, employing readily available prevention and detection measures. This is where we're going to start seeing our commonality, okay? So Windham is one case, and the question is answered is, does the FTC have the right to have the authority to regulate data under Section 5 of the FTC Act? Third Circuit said yes, it did not go to the Supreme Court. However, we still follow this through all the other circuits. Then came along at LabMD, and LabMD says, well, okay, you have the authority under Section 5, but there's two prongs. There's the unfair or the deceptive, and you're using prong 1. So we're gonna argue that you don't have this authority because you can't prove it. So the FTC judge agreed with LabMD, and this was overturned by the full Federal Trade Commission. So the original judge says, LabMD, you got a point. The full Federal Trade Commission, FTC court, an administrative court, said, no, you're wrong. But the rest of the story that is not in your book is that the 11th Circuit overturned this 2 years after this decision. And the court's opinion turns on the relief sought by the FTC, not the violation itself. And this is where we always fall into this abyss of what did the court say and what did they mean and how does that apply to me? A lot of times courts rule on the process. And so the court's opinion didn't say so much about the violation. It just said what relief, what FTC was saying you have to do to fix this. And it says the cease and desist order contains no prohibition. It doesn't instruct LabMT to stop committing a specific act or practice. It commands it to overhaul and replace its data security program to meet an indeterminate standard of reasonableness. And so the command is unenforceable. Now, this happened, I think, last April or May. I immediately updated my class notes and discussed this. It might have been earlier. It was one of my law and policy. So the point is, think of the timeline. Remember when I say how slow law is? FTC rules, and it takes it 2 years later to go to the 11th Circuit. And here's some an article you might want to read. When I went back and was doing my research, months before this case hit, the Reuters said, there's a big problem lurking in this 11th Circuit's LabMD security ruling. You all better be aware of this. If you don't read Reuters or some of these other news agencies, sometimes they pick up things we miss. As of today, well, it's all question marks, and here's why. Let's go back to our map, 11th Circuit, Alabama, Georgia, Florida. Why was it heard in the 11th Circuit? Because that's where LabMD is. Is that decision binding on the 5th Circuit? Nope. It isn't binding on any of the other circuits. At the same time, the Windham decision that came out of the 3rd Circuit, we adhere to. So when I have all the question mark, it's because this hasn't come back up in other appellate courts. And other appellate courts the circuit courts at that level, can decide differently. We currently have a split in the circuits, for instance, and we'll see this later in the class, of what constitutes an injury under the concept of standing that we'll get to in Chapter 2. We have some circuits that say you have to show me actual damage. You had a data breach, show me the damage. There has to be an injury. Other circuits say the mere threat that once your data is breached, the mere threat something can happen is injury enough. So there can be a split in the circuits. So this LabMD decision hasn't had as much impact in the past 6 months as one might reasonably think. Part of it is, quite frankly, prejudiced. My son is a corporate bankruptcy attorney in Houston. He's quite good at what he does. When I discussed this case with him just briefly, he said, yeah, but it came out of the 11th Circuit. Who listens to them? And that's true. That unfortunately or fortunately is true. The circuits we tend to listen to are the 9th, the 7th, the 5th, and the 3rd. And the 2nd sometimes, right? 3rd's a big one. 7th's a big one out of Chicago. 9th, of course, the 5th, because that's who's our circuit courts. So as of today, January 2019, I cannot give you a reasonable assessment how LabMD will now be interpreted. But to go back to this, it is not about the unfairness principle. It is about the fact that the FTC issued a consent order and, according to the court, said, hey, go fix your program, do this and do that, but it met an indeterminate standard of reasonableness. You will have other courts that say, I believe it's out of the federal court that came as Pennsylvania, that says if you don't have standards in place, then the reasonable standards will be those promulgated by the National Institute of Standards and Technology. Remember my first day when I said we're in an uncertain ethical and legal framework? Well, here's a good example. All right, so I want to talk a few minutes about the consent order and consent decree. Consent order is just that. I'm going to order you to do it. The consent decree is I've agreed to it. Sometimes I call it a consent agreement. It's consent decree. We had this Cambridge Analytica breach, but they had a consent decree with the FTC from 2011. They didn't admit to liability. And here's the thing. They didn't break any federal law. But under Section 5, the unfairness prong, they agreed with the FTC that maybe they should do better in ensuring the privacy of their users. So they didn't admit to liability, they didn't break any federal law, but they basically signed a contract with the United States government to change their policies. And now the FTC has a very strong case to say you failed. You didn't keep your part of the contract, and you know why this is a big deal? Take the number of users on Facebook and multiply it by 40,000 per day. That would be the fines. We'll continue to talk about this. Now that's all I'm going to talk about on chapter 1, and I'm spending more time on these earlier chapters. Listen to what I'm saying. Do the reading. Ask questions. Engage in the topic. That's it for this video. We're going to wrap up in video 4. Stay with me.